Well, let's still talk more on our discussions for today. This time we will understand the need to include an arbitration clause in a contract. My second guest, a senior advocate of Nigeria, Mr. Tunde Fagbohunlu, he explains that arbitration has been proven to be an effective means of resolving commercial dispute.
To be an arbitration if the parties had not before agreed that in the event of a dispute, the matter should be resolved by arbitration. And that is why you find, therefore, that typically it is only those relationships that are governed by contractual agreements that go to arbitration. So if I trespass on somebody's land, it's not likely to have been an agreement between me and that person beforehand that I would not trespass on his land, and in the event I trespass on his land, we will resolve the dispute by arbitration. It's not very likely to have, that's not likely to have happened. So you would find, therefore, that typically it's commercial transactions that go to arbitration. But the other forms of dispute resolution, like mediation, conciliation, negotiation, those are susceptible to any kind of dispute, except, of course, for maybe certain disputes that impinge on the public interest, like criminal cases or tax cases.
Is that why they say ADR is the best option for commercial disputes?
Yes, because commercial relationships to a large extent usually need to be preserved. And the atmosphere of public litigation tends not to be very conducive to preserving relationships, or indeed to preserving confidentiality. Whereas the private and oftentimes friendly atmosphere for arbitration and other forms of dispute resolution tend to be very conducive for preserving commercial relationships and preserving confidentiality. And I think that is why people say that ADR, namely arbitration and the other means of resolving disputes, are better for commercial disputes.
What's your view on the experience investors have as regards commercial disputes? Now, looking at foreign investors and local investors.
Generally speaking, arbitration, in my own estimation, when you look at the process of arbitration itself, has proven to be a very effective means of resolving commercial disputes. Litigation tends to be helpful, but obviously is vulnerable to certain weaknesses, institutional weaknesses. So the courts are very heavily congested. And I'll give an example, for instance. The average waiting time for an appeal to be resolved at the Supreme Court is anything from 8 to 10 years. So if a case has to go from the High Court to the Court of Appeal to the Supreme Court, the period of time it would take to resolve such a dispute could be, on the average, from start to finish, anything from 12 to 15 years. Now, that's the kind of experience that commercial people would face if they decided to litigate a commercial problem from the High Court up to the Supreme Court. But in my experience, cases tend to get settled by commercial people when they've been filed at the High Court. After the few initial skirmishes, cases tend to get settled on terms that are beneficial to both parties. In recent times, we've seen the phenomenon where you have ADR being attached to the regular court process. And that's particularly happening in the Lagos State High Court and in some other state courts all over the country, including the High Courts of the Federal Capital Territory, with an initiative that was started almost a decade ago under the name Multi-Door Courthouse by the Negotiation and Conflict Management Group. So you now have what we call court annexed ADR. And so the judges have become very sensitive and very sensitized to the idea that even though a dispute has been brought to court, even the judges themselves can use ADR mechanisms to ensure that parties get a quick resolution of their disputes, and that has worked very well. So this is one item I would flag as having been the experience of investors in resolving commercial disputes in Nigerian courts. But the other problems, of course, continue to exist, the institutional problems I talked about. And there have been so many efforts over the years to try to get it right, and those efforts continue. And I believe that with more efforts being made, with a better approach to understanding how the court system can work better, we would be able to get the courts to where we think they ought to be. Because even if, no matter how much we talk about ADR and arbitration cannot work unless the court system itself works very well. Because ADR is a consensual process. It does not always result, indeed, arbitration results in a binding decision. But you need enforcement, and arbitrators cannot enforce their own decision.
So do you think setting up commercial courts, that specialized commercial courts for commercial disputes, would help?
I think it will, without a doubt. First of all, because specialized courts means enhanced efficiency. You would have a group of judges or a team of judges who have specialized in handling commercial disputes, who have an understanding of what the needs of the commercial community are, who have some sensitivity to the importance in the economy of quick and effective resolution of commercial disputes. And you can only have those qualities when you have a team of judges who are focused specifically on resolving commercial disputes, in the sense that they belong to a specialized commercial division, which should be encouraged.
The cost implication using ADR and regular courts, is it really cheaper?
Well, I mean, again, yeah, you're going to have to, when you say ADR, look at it in the two components I mentioned just now, arbitration on the one hand and the other forms of dispute resolution. I would say clearly, and then again, you're probably asking me to compare that with the court system itself.
Yes. Is it really cheap?
Is arbitration really cheap? Is mediation and conciliation, are they really cheap? I think that it's very easy to say when you look at the types of fees arbitrators charge today, and when you compare that to the fact that when you go to court, you pay very minimal fees to file your case in court. You don't pay the judge to hear your case because the judge is a public servant and he is paid by the state. When you think about that, you are likely to come to the conclusion, to an intuitive conclusion, that arbitration is definitely more expensive than litigation. But what needs to be borne in mind is this: if you have a good case and you take a good case to arbitration and you win that case, you are likely to recover back all the costs that you have expended. Unlike in the courts, where there's a lot of controversy as to whether, if I win a case against you, then I'm entitled to recover from you all the money I paid my lawyer. So there's controversy about whether that can happen in court. With arbitration, it is specifically spelled out in the Arbitration Act that I can recover all the fees I paid to my lawyer. I can recover it from you because you lost the case. So for me, who took a good case to arbitration, or who defended a good case in arbitration, arbitration ultimately ends up being almost without any cost at all, because I recover everything back.
And for the person that loses?
It's very expensive business. But of course, is that not the way it should be? Because then it prevents people from taking frivolous cases to arbitration, and it prevents people from raising frivolous defenses in arbitration.
What are people's attitudes to drafting arbitration clauses?
I've had cause to talk on a number of occasions about, the attitude to dispute resolution clauses. People tend to call those clauses the midnight clause, and the reason why they say so is you can spend weeks or months negotiating a contract. So you would negotiate the price. If it was a contract for sale of a commodity, you'd negotiate the price, you'd negotiate the place of delivery, you'd negotiate all the other contractual terms, and you'll spend all the time negotiating all of that. And then just as you are about to sign, you remember that, oh, so what happens if there's a dispute? And then you just look for a standard clause somewhere and you just plug it in there. without thinking, is this clause relevant to my kind of dispute? Is this clause relevant to the kind of dispute I'm likely to have in future? It's always very important for parties to think very carefully about the clauses they are going to put into their contracts. I think there's an increasing tendency for in-house lawyers to be very conscious of the need to think carefully about the clause before they draft it. I've had a lot of questions being addressed to me in my professional experience to ask, if we put this clause there, what effect will it have? If we agree to do arbitration in England, what effect will it have? Can we agree to do arbitration in Nigeria instead? So counsel working for companies, are becoming more and more sophisticated in their approach to drafting these clauses, and I think that's a good development.
Arbitration institutions, government-owned or privately owned?
It's a mix of both. I mean, there are a number of arbitration institutions that are, if not necessarily owned, but at least inspired by government effort. One example, for instance, would be the Lagos Regional Center for International Commercial Arbitration, which is a collaborative effort between the Afro-Asian Legal Consultative Organization and which has a good amount of government support in the various countries where the center exists. So one exists in Kuala Lumpur in Malaysia, one is in Cairo in Egypt, there's one in Lagos in Nigeria, and they tend to be established under government patronage. So they are established by a statute, they are funded by government, they are international, they are fully fledged international governmental institutions. But then a good number of arbitral institutions are private initiatives, but they tend to be organized as companies, incorporated as charities, essentially. So they are not profit-making organizations. They are established as charities, and they are organized by private individuals, professional organizations, and they provide a very, very professional service.
So take note before you sign that contract. Make sure you include the arbitration clause. It might just be what will help you avoid the long and expensive process of going to court. I hope you have learned one or two things from today's edition of the program. Thank you so much for being a part of it. My name is Victoria Ido. Please send your comments to the address on your screen. Till I see you again, remember, love your enemies.